This article is from the Library of Parliament. Hill Notes. Research and analysis from Canada's Library of Parliament. Now, this specific article deals with human rights in emergency situations. So we're going to take a quick look into this article to see exactly what is being expressed and what is being put forth to the people who read this article, and then let us compare it to the authorities quoted to see if what they're saying is actually true or not. This article has some purposeful deception being brought forth or contained within it, which is surprising, I guess, because it comes from the Parliament of Canada. The article starts out by saying, in addition to obligations during peacetime, states have duties to respect and ensure human rights during wartime and national emergencies, in situations that represent a severe threat to a nation. However, the International Covenant on Civil and Political Rights, ratified by Canada, so now they're accepting responsibility and obligation under the covenant, allows for certain rights to be unilaterally set aside. So the premise of this article is talking about or dealing with setting aside rights, limiting and abridging rights. However, they do qualify their actions by claiming that certain rights can be set aside or certain rights can be limited and abridged. And that is indeed the case. When you look into the International Covenant, whatever right is expressed, whatever right is being brought forth, after the mention of the right, they will tell us, they will inform us if this right can be limited or not, and the reason why it may be limited. So let's see if this article agrees completely with the International Covenant, or if they are spouting deception within this. Continuing on in the article, it reads, the suspension of rights must be exceptional and temporary and is subject to the following safeguards. A state of emergency must have been officially proclaimed by the government. Measures to derogate from the covenant must be strictly required by and proportional to the existence of the situation. So here they're qualifying it now. They're saying if we're going to deviate, if we're going to limit or abridge a right that is brought forth through the covenant, which we ratified and are obligated under, then it has to be strictly required by or proportional to the experience that we are going through. And that's not the justification they're allowed to claim or use. The international covenants allow them to limit and abridge rights, however, not proportional to what they're going through, to what the covenant says. Remember, the controlling mechanism is the covenant itself. So therefore, if they want to limit or abridge any right, the covenant must allow them to do so. If the covenant does not bring forth the operation of law that allows them to limit or abridge that right, then irregardless of the situation, irregardless of the emergency, they are not to or do not have the operation of law to limit and abridge the right. They may do it, but they're doing it de factoly. They're doing it without the power behind them. The covenants are very clear about limiting and abridging rights. It simply says that during a time of emergency, this right may be limited or abridged. Remember, in Article 5 of the covenant, it states that nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights or freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. So the ruling factor, the governing force, the power in operation against rights or for rights is the civil covenant itself, what's expressed therein, not the situation around us. So the article is trying to say that the situation around us dictates or gives us the permission to limit and abridge rights, while the covenant says, no, it's not the situation around you, it's the covenant itself. We're going to enumerate a right, we're going to bring forth a right, we're going to recognize a right, and then we're going to dictate, or then we're going to state if the right can or cannot be limited or abridged. And if it can be limited or abridged, it shall only transpire during a state of emergency. The covenant is very clear. If you look in Article 4 of the International Covenant on Civil and Political Rights, it says no derogation from Articles 6, 7, 8, 11, 15, 16, and 18 may be made under the provision of an emergency declaration. So the rights and freedoms expressed and contained therein, those articles, and transferred over into the Constitution Act of Canada and into the Canadian Bill of Rights, are still in operation, even though there is an emergency being declared here in Canada and in the provinces. The powers that be, the powers that operate here in Canada, they need to declare or have a declaration of emergency in operation in order to exercise their powers that they are doing to limit and abridge rights and freedoms. So within the context of law, they need the emergency declaration to be operative, in operation. Then they can see how far they can push to limit individual rights and freedoms. Remember that it's only during a time of emergency, according to the covenant, that those certain rights and freedoms may be limited and abridged, not all rights and freedoms. Now, looking into the covenant, I'm going to read you Article 21, or quote from there. The right of peaceful assembly shall be recognized. No restriction may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health or morals, or the protection of the rights and freedoms of others. So under a declaration of emergency, they're saying that they can place a restriction upon the right of peaceful assembly. And here the covenant is saying that, yes, because it's not one of the articles that were protected above in Article 4, where it enumerated and listed the numbers which brought forth the rights and freedoms that were protected that could not be limited and abridged. So Article 21 is subject to a limitation. Now, it's subject to a limitation how? If there's an emergency, a health emergency. So an emergency is declared in Canada, emergencies are declared in the provinces, and bang, the operation of law exists for the powers that be to try and limit and abridge the right of peaceful assembly. Now, if you look closer into the article of law internationally, and I'm not going to really get into that aspect in this video, but listen to what it says here. And for those who have followed me over the years, they're going to understand what's being said here. The right of peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society. So this is impacting or affecting the democratic society, the political body, the artificial person, the subject in law, whoever you may be in the time that they intercept you. If you were fishing, you're the fisherman. If you were driving, you're the driver. If you were at the store, you're the consumer. So this is going to operate within the democratic society as that class of person, that class of being. And that class of being, its right to peaceful assembly has now been limited and abridged through this emergency, and the operation of law that's being used is correct and is backing them up. But does that apply to you as a man or a woman? If you don't operate under the capacity of the artificial being, that class of person? No. Why? Because then you stand outside the democratic society, right? So therefore, that limitation or abridgment shouldn't be allowed to be placed upon you. But when people go outside to assemble, they have no idea how they're assembling or under how the law views them when they are assembling. So therefore, when the police come by and say, hey, you can't be doing this, and the government said, don't be assembling, we're limiting and abridging this right, we have the power and the operation to do so, because it's a democratic society and you're a class of person, let me see your ID so I can identify you as a citizen and give you a ticket. Because a citizen is a class of person, right? Reading the third paragraph down. The Emergencies Act explicitly recognizes the importance of upholding human rights during crisis by stating that any measures taken under its authority are subject to the Canadian Charter of Rights and Freedoms, the Charter, and the Canadian Bill of Rights, and must be guided by the ICCPR. Now, is that all that it says? Or are they omitting a very important quote, a very important operation of law that is contained within the Emergencies Act itself, which they are failing to enumerate here, which says that during the time of emergency and during the subjection of the Emergencies Act to these authorities, the Canadian Charter of Rights and Freedoms, the Canadian Bill of Rights, and the international covenants, the ones operating and making these declarations in the times of emergency must have regard to the rights and freedoms that can never be limited or abridged, even during a time of emergency. So those in power that are making these declarations, they're under responsibility to make sure that they're not limiting and abridging fundamental human rights and freedoms that are not to be limited, period, no matter what's happening around us. The fourth paragraph, it reads, in line with the ICCPR, the Emergencies Act requires the federal government to issue a declaration for all national emergencies, including public welfare emergencies, which can be caused by diseases in human beings. This act places several limitations and requirements on the declaration of such emergencies. Reading the first paragraph, the Canadian Charter of Rights and Freedoms in the context of a pandemic. The declaration of an emergency at the provincial, territorial, or federal level in the context of a pandemic has important impacts on the human rights guaranteed under the Charter. For example, measures to prohibit gatherings in public spaces, as well as in people's homes, could infringe on freedom of peaceful assembly guaranteed by Section 2C of the Charter. Freedom of religion, guaranteed by Section 2B, could also be affected by orders to cease religious services to prevent large gatherings of people. So here they're saying now, they're bringing forth in this article that, for example, measures to prohibit gatherings in public spaces could be infringing on people's rights. When we directly looked into the covenant, and the covenant said, listen, during a time of emergency, the powers that be, the government bodies, have the right to limit and abridge this right. They can stop public gatherings because there's an emergency, and they're operating under an operation of law that guarantees their protection internationally, that guarantees to say, listen, you haven't broken your covenant obligations. But now here, this article is coming forward and saying, well, listen, if they limit your right to gather, and that's a charter right, then you know there's a potential of there being a problem. And it's just a smokescreen. They love to do that. Someone reading this article that doesn't understand their rights and freedoms as a man or a woman, and doesn't understand their obligations to civil rights as a class of being, this would totally go above their head. Those who have some knowledge and some base and some foundation of what's going on here in Canada will understand what this is saying and the game that's being played here. So here they're saying, listen, you know, and then they equate it, or they yoke it to the next one, which says that, or if they try to infringe upon your right in people's homes. Now notice that they bring forth the character or the class of person of people. And we know what people means. And if you're a people in your home, then yeah, I'm sorry to say, they do have the right to regulate you. Because the people is part of the democratic society, and the people is a class of being. But if you're at home as a man or a woman, then truth be told, under the law, they don't have the right to tell you what you can and cannot do in your home. Even the enactments that they use during a regular time, and I'm not going to get deeply into this. If you followed me over the years, the past 10 years that I've put out videos, then you have a pretty good understanding of what's going on. But the enactments that they use, they designate you as that class of being, that class of person. They apply the enactment, and then they control your actions at home. It's no different what they're doing here. And this article, by using the designation people, people's homes, it's very clear what they're doing. So they're saying that they can limit the gatherings that's taking place in public areas or in the people's homes due to a pandemic. And sure enough, they can. But again, are you a people at home, or are you just your family, man and woman, child? End of story. All right, let's look at that third paragraph now here. Importantly, Section 1 of the Charter states that these rights are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So there you go again. Free and democratic society? Fine. You voted for your representatives. You voted for the government body, the ones in power. They're representing you. They're making the decisions. They have the right to make those decisions as long as they stay within the context of international law, as long as they stay within the context of the operational law that's available to them, then they have the right. Do they stay within those contexts? No, I'm sorry to say. Why? Because the majority of Canadians have no idea what's going on. As I said before, it's a big smokescreen around them. They have no idea of their rights and freedoms. They have no idea about what's transpiring in the law. So therefore, the government can push the boundaries, and there's very little reaction to it. Further on, it says, in addition, Section 33 permits Parliament or a provincial legislator to declare that a piece of legislation may operate notwithstanding Sections 2, 7, to 15 of the Charter. And I guess that should mean 7 or 15 of the Charter. Now, here's a very funny thing being brought forth. Again, if you followed me, I'm sure you've caught it already. But these people writing this article are trying to claim that in Section 33 of the Constitution Act of Canada 1982, that this Constitution, this article of law, permits the Parliament or a provincial legislator to declare that our individual rights and freedoms as men and women do not operate. The rights in Section 7 do not operate in a time of emergency. And that the Parliament or the legislator can make this declaration just out of the whim. Okay, we're in an emergency situation, and we as the Parliament declare that this enactment, the quarantine enactment, will operate despite the fact that it's limiting and abridging your fundamental human rights and freedoms in Article 7. We make that declaration. This is what the article is trying to declare and bring forth, that the operation of law provides to them, which is total garbage. If you actually look in Article 33 of the Constitution Act of Canada, Section 33 reads as follows: Parliament or the legislator of a province may expressly declare in an act of Parliament or of the legislator, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of the Charter. So here it's clearly saying that the Parliament or legislator of a province may expressly declare in an act. They have to declare in the act at the time of creation. So I'll explain to you how that works out. So they're making a new enactment. They're making a regulation. And in this regulation, in this enactment, they're about to place a limitation or abridgment upon the fundamental right and freedom of a human being. The fundamental right and freedom of a man or a woman. Now, their obligation, once they place this limitation or abridgment upon the right, is to declare Section 33 and saying, this operation of law, this limitation or abridgment of the right, operates notwithstanding the Constitution Act of 1982. That's what they're supposed to do. That's the operation that's being used. And it has been used a few times in Canada. And I've shared it in the video of past which I've made. However, the courts don't accept it. Even though they use a notwithstanding clause. Why? Because you cannot place a limitation and abridgment on a natural right. It doesn't matter how many enactments, it doesn't matter how many regulations, it doesn't matter how many laws you want to create. You're not allowed to do that. Universally, internationally, and even domestically. So what do? You change it, you take us out of our capacity, out of our recognition of a man or a woman and a child, and place us under the law as a class of being, as a class of person, the driver, the student, the fisherman, the hunter, the reporter, the consumer, and those class of beings, those class of persons, you regulate and control through your enactments, through your regulations, through your statutory powers. Statutory being, statutory powers. Human being, man or woman, fundamental rights and freedoms, natural rights and freedoms, which are never to be limited or abridged. The article reads as follows. Again, in addition, Section 33 permits Parliament or a provincial legislator to declare that a piece of legislation may operate notwithstanding the Charter. That's not what it says. It says that Parliament or the legislator of a province may expressly declare in an act of Parliament. So the article is saying, well, if you make a declaration with your words of your mouth, boom, now you have the power to say, this operates irregardless of the Charter. But that's not, the Charter does not say that. The Charter does not say make a declaration with your mouth. The Charter says that if you include the declaration within the enactment, within the statutory power itself, then it would be considered to be operating unless, I guess, some man or woman comes across that limitation and abridgment and says, whoa, 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 what did you do here, legislator? What did you do here, people sitting in a suit around the round table trying to limit and abridge my rights? This is a no-no. Even though you use the notwithstanding clause, you're not supposed to be doing this. This is my natural right, and I'm going to come and get it back. So that's tracking. Tracking your cell phone, your iPads, and your movements like other countries have already been doing. That's Canada's next step. They've been preparing you for this. Privacy rights in the context of a pandemic. Although privacy is recognized as a human right in the ICCPR, it is not explicitly set out in the Charter. The right to privacy is nonetheless protected under the right to be secure against unreasonable search or seizure, which is Section 8, and is considered to be a component of the right to life, liberty, and security, Section 7. Privacy protections are also contained in the federal and provincial privacy legislation, which has been granted quasi-constitutional status by the Supreme Court of Canada. According to the Privacy Commissioner of Canada, privacy laws include several provisions that authorize the collection, use, and disclosure of personal information in the context of a public health crisis. If a formal emergency is declared, the powers may be further extended and can be very broad. Many countries have already started using tracking tools to collect data on their citizens in order to track the progression and spread of COVID-19, some to great success, like South Korea, and others, like Israel, under much controversy. The Canadian government has so far resisted using such tools, although the Prime Minister has not ruled out the possibility of tracking cell phone location data to limit the spread of the virus. Now again, if someone's just reading this article, boom, like a bullet or like a rocket, just right over their head. Okay, I guess they have the right to limit and abridge my rights here, so that's what they're telling me. They have no idea what this article is doing and how it's jumping through different players, different designations in law, different from civil rights to fundamental rights. We look at the first paragraph, and who are they talking about in Section 7? Who do those rights apply to in Section 7? Does it apply to the class of being, the class of person, the statutory creature designated the citizen? Does it apply to the hunter? Does it apply to the statutory being designated the fishermen? Absolutely not. We know that Section 7 rights only apply to everyone. Huh? What do you mean, John? Everyone? Uh, what do you mean, everyone? Yeah, exactly. To everyone. And if you don't know what that word means here in this context, you better go watch some of my videos. Because guess what? If this pandemic, what they're calling a pandemic, keeps getting worse and worse and worse and worse, you better know how to defend your fundamental rights and freedoms. You better begin to wake up and understand what this evil law has done to you as an individual by stripping you of, first of all, your understanding of who you are in this system, and secondarily, of the operation of your rights and freedoms. But for those who are sort of awoken and understand what's going on here, so they're quoting everyone in Section 7. And they're saying, well, this everyone has the human right of privacy. And then they give some authority to back up their position of the fact that everyone has the right to privacy. Then they go on to list and talk about the fact that they will be tracking, or it is taking place right now, the tracking of the citizen using cell phone locations and so forth, tracking apps and so forth. So they jump in first with the everyone, and they say everyone has the right to privacy. And then they jump on the citizen, and they say, well, the citizen we can track. So they're saying we can limit and abridge the citizen's right to privacy. And that is the truth. That is the case. The citizen would not be protected under Section 7 of the Constitution Act of Canada. And therein lies the truth about it. When you're interacting with them, what designation are you standing under? What are you being recognized as? Are you the citizen? Then guess what? They're going to track you. Are you the citizen? Then they're going to limit your privacy. They're going to limit your right to assemble. Because why? Because that's the operational law they have. And you're exercising civil rights. And they can limit and abridge these civil rights. But you don't have to exercise civil rights. If you read the Quebec Civil Code, which is just an expression of statutory law and common law in operation, but if you take the time to read the Civil Code, you'll find within the Civil Code an interesting article of law, just sitting there, enumerated by itself. And it says that someone, and I won't designate the character here, but someone has the right to shake off their obligations to exercise civil rights as long as this shaking off of the obligation to exercise the civil rights is in accordance with the principle of fundamental justice. Isn't that a beautiful statement? When you understand what that's saying? Yeah, some of us know that and understand that and exercise that, but it's nice to see it contained in their own document, so clearly brought forth and enumerated. Should state surveillance occur in Canada, it would have to be deployed in accordance with the law, whether the Emergencies Act or privacy legislation. You forgot something there, buddy. It'd have to be deployed also under the obligations of the Charter of Rights and Freedoms and in context with the international covenants. And as you just stated previously in your first paragraph here, Section 7 affords that player the right to privacy. Don't track me. Don't follow me. Don't impede upon my privacy. Now your third paragraph, yeah, absolutely. If you want to bring forth that context, you're going to track your citizen, you're going to track your statutory creature. Well, by all means, I guess you have the right to do so. And 99.9% of those statutory creatures who are operating have no idea what's transpiring and have no idea that a limitation and abridgment has been placed upon their fundamental right so that you could limit and abridge their civil right. So sure, you're going to do it. But there's a few of us across Canada that know the deal, so to speak. And if you push that point with those individuals, I guess the judiciary will be having cases being filed eventually when things get back to normal, if they get back to normal. But nevertheless, be a good master to your slaves and those who are aware of the game you are playing in the law. Give us the key, unloose the shackle. Don't bother us. You have enough pawns in your scheme to play with. You have enough individuals who you have limited and abridged their rights that have no idea that you've placed them in bondage, put shackles upon their life, and control their every actions and their every move by designating them a certain class of being and then placing laws upon them to say, as a fisherman, you have to follow these rules. As a hunter, you have to follow these rules. As a driver, you have to follow these rules. As a citizen, you have to follow these rules. As a student, you have to follow these rules. Wonderful. And not allowing them just to be free, to live a free life. As a man or a woman, free from the influence of those laws. Now, the kooks who might come across this video are going to say, oh, you can't just be free. You have to have laws. You can't just not have laws. It's because you don't understand the difference between statutory law and a regulation that controls a class of being, a class of person, and common law, such as don't steal and don't kill, which are contained in the criminal code thereof, which protects individuals and your democratic society. But this is not what this video was about. This video was about saying, wake up, be careful, you better know your rights, because if they drop the boot on you and want to quarantine you, throw you into quarantine camp, follow you, track you, limit your right of assembly, they're doing it all through their operation of law that designates you their class of being, their little slave, in words, on paper, and you don't have to accept that. You might have to if they come with police, with guns, and say, we want you to do this, we want you to do this. Well, yeah, hey, I'll do whatever you want, and, I'll deal with this limitation and abridgment after. I'm not going to give you the opportunity to pull a gun on me. I'm not going to give you the opportunity to make trouble. Absolutely not. Whatever your master's ordered, I understand you're fulfilling a procedure, you're following orders, and you yourself don't understand what's transpiring. You don't understand the limitation and abridgment of our fundamental rights, and you're following the herd. So I'm not going to blame you. All I'm going to do is go and see those who have the authority to deal with the executive powers of this government, who think that it's a game to limit and abridge people's rights because they think we're stupid. And I guess in a way we are stupid. Why? Because we know about Beyonce, and we know about Justin Bieber, and we know about Dwayne Johnson, The Rock. Big Rock, The Rock. But we have no idea about who we are, about how we're being controlled, and about what the law and the powers have done to our lives. And now we're facing the consequences, and we're saying, this sucks to be stuck in my house and can't do nothing, and they're telling me I can't do anything. Yeah, because they're using their disgusting law that limits you, even though they're not supposed to.